Okay. Good morning, everyone. It is just a minute past 8:30, so we will go ahead and get started. Thank you all so much for joining us today. My name is Stephanie Silva. I am the Worcester Regional Chamber of Commerce Programs and Events Coordinator. I am so happy to be here with you all today, and thank you for joining our Chamber Seminar Series. Today, we are talking about estate planning, and you are in great shape with Mr. Anthony Draga, who I will introduce shortly. But first, I just want to go over a few housekeeping items, and then of course, thank our sponsor for hosting us today. So as you know, we've been doing this Zoom thing for quite a while, but I have to say it. So if you could just make sure that you are muted for the duration of Anthony's presentation. We are going to have some Q&A, so happy to hop off mute for that portion. And feel free to ask questions when we get to the end of the presentation. Also, please utilize the chat box. So I'll be monitoring the chat box. If you have questions that come up during Anthony's presentation and you want to type it in there so you don't forget it, please do. I'll make sure to ask on your behalf at the end. And then also, please feel free to type in your name and business contact information. This is also a networking opportunity, so go ahead and share that so we can follow up with each other after today. Today's session is sponsored by TD Bank, America's most convenient bank. I do have a statement here from Anthony Pasquale, Regional Vice President of Central Mass TD Bank. TD Bank is proud of its long-standing partnership with the Worcester Regional Chamber of Commerce in sponsoring relevant educational events that benefit our local business community. We hope that you find today's series topic useful with actionable takeaways, and I can guarantee that you will do that today. All right. So I'm going to stop sharing my screen here. And what I'd like to do now is introduce our speaker, Mr. Anthony Draga. So Tony Draga is a highly regarded attorney at Bowditch's estate, financial and tax planning practice area, helping clients in Massachusetts with a variety of matters, including the preparation of administration of estates and estate plans. Business owners, distinguished professionals, senior executives, and high net worth individuals turn to Tony to develop personalized plans to reduce or eliminate estate, gift, and income taxes. Clients also rely on Tony in a variety of matters, including the investment of division of assets, identification and appraisal of estate and trust assets, preparing and filing federal, state, estate tax returns, and collection of life insurance and employee benefits. My goodness, what a job you have, Mr. Tony. So thank you so much. We're so happy for you to be here today. We've been anxious to have this conversation. I know it's one that I don't know much about, so I'll certainly be sitting back taking my notes, and I'm sure I'll have a lot of questions at the end. So with that being said, it is all yours.
Thank you so much, Stephanie, and thank you to TD Bank North, or TD Bank, excuse me, as the presenting sponsor for today. Just one quick housekeeping matter, Stephanie. I believe the screen share is still kicked back your way. I don't know that at the present moment, if I can turn on my PowerPoint presentation.
Okay, let me double check here. Always something.
The one upshot, if we would have been a live presentation, is I could have had somebody else control my technology.
I know. All right, you want to try that?
The only other difference is I get to use my my ceramic coffee mug instead of a travel mug, which is always good for me. Always good for me. I'm still, when I go to share screen, yes, I've got it now.
Okay.
All right, perfect. Wonderful. All right, folks. Well, thanks so much for taking the time. I'm going to turn off my audio or my video while I deliver this presentation. But today's topic, as you know, is top 10 estate planning questions. It's not meant to be a deep dive, but rather an introduction to a number of estate planning topics. As we sort of go through this material, we can certainly, as Stephanie mentioned, there's going to be a Q&A at the end. But I also do invite you to reach out to me. I've got my contact information on this slide here. But I also will have it at the end of the presentation as well. So the first question, and the sort of the biggest one that I think is on everybody's mind is what is an estate plan and why should I have one? It sounds pretty basic, but it's important to sort of think about this in a global perspective. An estate plan is a plan for the management of your assets during your life and the disposition of those assets after your death. So that's sort of the larger definition. And as we get to the why, a big one is that you want to be able to dispose of your assets in an orderly fashion. If you don't have an estate plan, then you don't get to direct where your assets go at your death, or at least those assets that would be subject to probate. The Commonwealth of Massachusetts, or whichever state to which you're domiciled, where you live at your death, has a state law that dictates how, where assets go. And generally speaking, it's to the surviving spouse and then to the children. But if you have any other plans or intentions for how you'd like your estate to be disposed of, you don't get to designate that if you don't have an estate plan. Another reason to have an estate plan is to designate a guardian or conservator for minor or disabled children. This is relatively self-explanatory, but under your will, you have the opportunity to name those folks that you would wish to maintain important roles in the lives of your children. The guardian, I'll talk a little bit more about this later on in the presentation, is in charge for the health and welfare for a minor or disabled child. The conservator is responsible for the financial affairs of an individual. We're going to focus a fair amount on the minimizing or elimination of estate taxes. This is really an important one, and I imagine a few of you here on the presentation are interested in that, as this is the chamber. To provide financial management for family members. We're going to talk a lot more about that during this presentation. To plan for your own incapacity, and to protect assets, particularly from claims of creditors. One great example that folks might not really be thinking about estate planning when they hear this, but it really is an estate planning tool, is the use of LLCs to own rental real estate. That LLC protects other assets from the claims that could accrue from the management of a rental real estate property. Really sort of keeps it isolated, and it protects the rest of your estate. So that's sort of one example there. Lastly, we have the providing for charities, being able to direct your charitable inclinations either with lifetime giving or at your death. Question 2. What are the basic documents that make up a typical estate plan, and what do those documents do? First, we have the will, so the most basic of estate planning documents, and the will disposes of probate assets. Just from a definitional perspective, a probate asset are those assets that are not jointly held, they don't have a transfer on death or beneficiary designation. So an example, if you own your house outright and you're the sole owner of the house, when you die, that will be a probate asset. Another example would be a vehicle. You can only generally have one person's name on the title. Generally speaking, a vehicle would be a probate asset. And then lastly, say an investment account to which you don't have a co-owner or beneficiary designation. That's another example of a probate asset. We have the durable power of attorney. The durable power of attorney is a document that basically appoints an individual or designates an individual to be able to conduct business on your behalf. The real importance of a durable power of attorney generally comes later in life. If you've got any form of disability, the durable power of attorney allows an agent to operate on your behalf without requiring anyone to go into the probate court to have a conservator appointed. We have 2 different types of powers of attorney in Massachusetts. We have what's called a springing power of attorney, or just again, the traditional durable power of attorney. The springing power of attorney only springs into effect in the event that a doctor deems you to be incapacitated. The traditional durable power of attorney is effective upon signing. It may sound good to have a springing power of attorney, to have more control in your own business affairs, but that really generally presents an extra layer of complication because you need to get a physician involved in order, and sometimes there's sort of that gray area of whether or not someone's really able to conduct their own affairs. So a vast majority of the powers of attorney that we recommend are the sort of traditional durable power of attorney. Next up, we have the healthcare proxy. The healthcare proxy, in contrast to the power of attorney, only comes into effect in the event that you are deemed to lack capacity, from a physician. But that allows an individual to sort of stand in your shoes to make medical decisions. Medical capacity is sort of a fleeting, it's a changing standard. So, you might be going in for a surgery and need to go under, as it were. A power or a healthcare proxy might spring into effect to impact any medical decisions that need to be made during that time. But once you are back on your feet, that healthcare proxy is taken out of effect, and you're able then to retain control of your own medical decisions. So the healthcare proxy operates more like, say, the springing power of attorney, but it only really has legal effect if you are unable to make medical decisions for yourself. Lastly, we have the Hipaa Authorization. The Hipaa Authorization is also known as a medical release authorization. And that is really just an access to information. It usually works hand in glove with the healthcare proxy, and individuals named on your healthcare proxy. A lot of times, folks who have adult children might name their adult children, even if they're not on the healthcare proxy, they might name them on the Hipaa Authorization, and that's just an access to information that allows medical providers to share information with the individuals named. We can do that, and that's generally thought about in two different ways. You can, if you really want to protect your medical information, you can say that the Hipaa release only comes into effect in the event the healthcare proxy is activated, meaning that if you are incapacitated, then your healthcare information can be shared with your named agents. The more common approach would be to have this Hipaa authorization signed such that anybody who's in your close circle, anybody you name in that Hipaa release, would have the ability, to talk to the doctor if you break your ankle on a ski trip or something like that. Next up, do I need a trust as part of my estate plan? The answer is it depends. There are a lot of different types of trusts. You're probably sort of basically familiar with trusts. I'm going to start by talking about sort of two broader categories, and then we're going to focus our discussion a little bit. First, we have living trusts. Those are trusts that are created during your lifetime. They can be funded during your lifetime, and it sort of comes in two categories. One is a revocable trust, meaning that it can be amended at any time up until your death. The other is the irrevocable trust, in which once the document is signed, but for a few exceptions, what you see is what you get. It's its own sort of living, breathing trust for in perpetuity after it's created. The other category of trusts are what are called testamentary trusts. Those are trusts that are created under your will. There are some circumstances in which a testamentary trust is preferable. Here in Massachusetts, it's not really a favored tool, in large part because after a testamentary trust comes into effect, after you pass away, the probate court needs to be involved on an annual basis for the life of that testamentary trust. So there are a lot of extra expenses related to the maintenance of a testamentary trust. In some states, such as New York, testamentary trusts are actually the standard. So the information I'm providing is focused a little bit more Massachusetts, or a lot more Massachusetts, I should say. And so we're going to really focus our discussion on the living trusts. The sort of benefits of trust planning are that we can minimize estate taxes. Again, we're going to talk about that a little bit more in a later slide. You can hold assets and provide financial management for your family members. This is particularly critical for if you have minor children or beneficiaries with special needs. You can protect assets for your own sake and for your beneficiaries. Some great examples that may sort of bring a little bit of life to this is if you've got a child who's in a challenging relationship and maybe moving towards divorce, or if they're engaged in a high-risk profession, the trust planning is a great way to control their trust in a way, their assets in a way that can keep those assets from being exposed. Trust planning is a great way to plan for your own incapacity. If you create and fund a trust during your life, then in your later years, if you aren't as able to maintain your day-to-day affairs, your trustee can stand in your shoes, and that's a really great tool. Probate avoidance, we're going to talk about this. It's in more detail during a later part of the presentation, but the opportunity to avoid probate altogether, avoid the expense, the time, the publicity that comes with probate can be really beneficial. And then lastly, to make charitable gifts. Charitable gifting is a large part of people's estate plan in a lot of circumstances, and the trust is a great vehicle in which to achieve that. We can even create charitable trusts that allow you to make gifts during your life, receive income tax deductions for those gifts, while also getting an income stream in return. We're going to talk about that just a little bit later on in the presentation, but that's a slightly more technical estate planning tool. Next slide. If I need a trust, will it be revocable or irrevocable? Most trusts, for a standard basic estate plan, most trusts are revocable until the person who creates the trust passes away. So first we'll talk about revocable trusts. They're fully amendable during the grantor's life and only become irrevocable at death. They're frequently used to avoid probate, to provide for the incapacity of the creator of the trust. They can minimize estate taxes. This is particularly valuable for married couples with assets over $1 million, even more so for married couples with assets over $2 million. And we're going to do some real basic back of the napkin math to sort of illustrate that. You can provide financial management for minor or special needs children after the donor or grantor's death. And you can protect assets for beneficiaries. So this is a little bit of a repetition from the last slide. Trusts that are irrevocable by the grantor during life are frequently used to hold life insurance to remove the death benefit from the insured's taxable estate. We're going to talk about this in a later slide. To receive gifts made for estate and income tax planning purposes, you can use irrevocable gifting trusts to make gifts that reduce your taxable estate when you pass away, but also allow you a certain amount of control. Generally speaking, when you make gifts in the estate planning context, you don't get to control what happens to those proceeds. You know, after you make a gift to your child, for example, you may tell them what you want to do, what you want them to do with that gift, but you generally sort of lack a certain amount of control. While using irrevocable trusts, you can make significant gifts and dictate the terms of those gifts. Finally, irrevocable trusts can be used to plan for long-term care. This is commonly used when people think about mass health planning. Irrevocable trusts are often an important tool to hold assets for the benefit of individuals who are looking to qualify for mass health, but are over the asset limit at that time. Again, that's another technical area that we're not going to spend a whole lot of time on today. If I have an estate plan, how frequently should I review and update it? The short answer is it depends. It's just like everything else in the practice of law. But our common recommendation is that folks should consider reviewing their estate plan every few years. Oftentimes, updates are subtle and small once you've developed your core estate planning documents. With adults who have adult children, oftentimes the update is really as simple as perhaps adding their children into fiduciary roles, say as backup healthcare proxy or durable power of attorney or successor trustee. Sometimes changes in family dynamic are a good reason to revisit one's estate plan. If you've got a death in the family, if your family's growing, that's all reasons to just review the estate plan to make sure it's still consistent with your wishes. It's good to update your estate plan or at least review it when you have significant changes in your finances. This review is critical because a big part of estate planning that people, I think, generally don't think about is making sure your assets are properly positioned. A trust only goes, is only as good as the assets that fund it. And if you create a trust, but all of your significant assets name your spouse, for example, as beneficiary, then there's no way to fund that trust. So it's important that you work with your estate planning counsel and your financial advisors to make sure that your assets are properly positioned. And lastly, if you change your state of domicile, so you should absolutely review your estate plan. It's not uncommon here in the Northeast for folks to, become snowbirds and perhaps start to spend more and more time down in Florida, for example. Well, there's a real benefit to the Florida tax laws, so it's a good consideration to revisit your estate plan once you're down there to make sure that you're optimizing your potential estate tax obligations. As promised, we'll talk a little bit about probate and why you should be concerned about avoiding it. Probate is just the technical term for the process in which your will is filed with the probate court in the county of your final residence. And it's also the document which nominates, appoints your personal representative. If you don't have a will, your estate could still be offered for probate, but what we call the Intestacy Laws are what control. Intestacy laws, again, are basically just a statutory, a Massachusetts state law which dictates how your assets would be distributed in the absence of a will. It's a percentage-based system. If you have a surviving spouse, they're your primary beneficiary in every event under the intestacy laws. But then we sort of get into the minutia of how children are treated, how children within a marriage and outside of a marriage are treated. It gets very complicated. So the suggestion is always to have a will. It's not as bad as people make it out to be. I think people have this sense that you'll be stuck in a maze at the probate court for years. Every estate gets tied up. That's not really the case. But if you can avoid the time and expense associated with probate, it's going to be better off for your beneficiaries. So that's certainly something to consider. If you can substantially avoid probate, you can allow for seamless and almost immediate access to the management of assets. If you've got a trust that basically all of your probate assets pour into, otherwise probate assets pour into, then the trustee can be appointed without going into the court. That trustee can then manage, funeral arrangements, paying for funeral arrangements. They can manage the sale of a house or really any of the other logistics associated, immediate logistics associated with paying last expenses and all of that stuff as well. Again, without the time and expense of the probate court. Another major benefit here is that if you can avoid probate, then you can protect assets from the claims of creditors after your death. It's hard to completely avoid probate because there are a lot of assets that don't have beneficiary designations. There are some assets that you can only own in your own name. I'm again thinking about a car, for example, and so at your death, it may require the opening of a probate. But in the event you are able to avoid it completely, if you have a surviving spouse, for example, you may be able to avoid it completely. Your will is never published. It's never put on the public record over at the probate court. Any creditors you may have are not necessarily put on notice of your death. It's just a more efficient process if you can avoid it. A really important note here, the final bullet point on this slide. Avoiding probate does not in and of itself save estate taxes. That's a really critical note, because I think people have a misconception there. If I have my assets pointing to a trust, or if they're owned by a trust, that in and of itself is saving me estate taxes. That's not the case. You need to have particular tax planning involved in order for the savings of estate taxes. And that brings us to our next slide. Will my family or estate pay estate taxes? And if so, how much will have to be paid? So the tax, if it's due, is paid by the estate, not the beneficiaries. And what I mean by this is, if there's an estate tax obligation, the estate, the personal representative for the estate, will work with an accountant or an attorney to prepare the estate tax return. The estate taxes will be paid off the top, and then the beneficiaries will receive their distributions. Here in Massachusetts, we have the lowest estate tax threshold in all 50 states. We're tied, I believe, with Oregon. $1 million is the threshold amount. Federally, this has been in the news a lot, but because it might change under the new tax regime that the Democrats are talking about. But federally, the estate tax exemption is $11.7 million per person. So you can see there's a really, really big gap there. Massachusetts estate tax rates are progressive, just like our income tax regime. And they go as high as 16% for estates over $10 million. An important note here is that the $1 million filing threshold is just that. It's a filing threshold. You can't make taxable gifts. You can't give away all your money right before you die in hopes of getting under the $1 million threshold to avoid paying the estate tax. If you make any gift that is taxable, meaning a gift to an individual that is more than $15,000 in any given year, you can't use those big gifts to get yourself under the $1 million threshold. Absent deductions, the estate of a single resident dying with $2 million would pay about $100,000 in Massachusetts estate tax. So at that level, we're talking about a 5% state estate tax. If you've got a single resident with $5 million, they would pay almost $400,000 in estate taxes. So that we're getting up in the progressive structure to about 8%. So the example that I like to use here is you take a couple that has $2 million at the death of the first spouse. If they've got simple wills in which everything is held jointly and payable to the spouse or each other as beneficiary, then at the death of the surviving spouse, if that surviving spouse still has about $2 million to their name, we'd be looking at about $100,000 in estate tax due. If that same couple with the $2 million has trusts prepared that have tax planning in them, then we have the ability to basically protect the entire estate from taxation. The way that works is at the death of the first spouse, we'd be able to create a sub-trust, which is called a credit shelter trust of $1 million worth of assets, carve those out at the death of the first spouse. That $1 million trust would be for the benefit of the surviving spouse and any descendants. The surviving spouse would still continue to have $1 million to their own name. At the surviving spouse death, that first trust is not subject to tax, that avoids taxation. And if they've got less than $1 million to their own name, say they've got $800,000 to their own name, then that's under the filing threshold. We've now avoided estate taxes entirely. So that's sort of an illustration of, for a moderately wealthy family, that's an illustration of how to avoid estate tax entirely. At the federal level, the estate tax exemption currently is really, really high. It's $11.7 million. Next year, moving to $12 million if there's no change in the estate tax regime. This is an enhanced federal estate tax amount. If the Trump tax cuts expire at the end of 2025, as they're currently set to, then this federal threshold basically gets cut in half to about $6 million, subject to inflation. But the example we have here, if a Massachusetts resident died with $15 million to their name, they would pay a combined $2.4 million in federal and Massachusetts estate tax. The bulk of that would be the federal estate tax, because as you can see here, the federal estate tax rate, even though the filing threshold is very high, the tax rate is also really high. So if you die with a lot of money, you're going to pay a lot of federal estate tax. The last big note, and this works into our into the hypo that I had already given, was that there is an unlimited deduction for assets passing to a surviving spouse. But assets that do pass to the surviving spouse will be subject to estate tax absent trust planning at that surviving spouse death. So if you use revocable trust to fully utilize the applicable estate tax exemption, then you can limit your estate tax exposure at the death of the surviving spouse, while also allowing that spouse the access to those funds as they need them for the remainder of their lives. The last big note for those of you who are charitably inclined is that there is an unlimited deduction for assets passing to charities. A big question that folks often have when they come into my office is how to provide for minor children in one's estate plan. One sort of primary way is to name guardians or conservators under a will. These are nominations. They are not in themselves appointments. So if you name your, a sibling to serve as guardian for your kids, if you're not around, and they're not able to serve for whatever reason, someone else can step up and if they're named in the document or if they're a family member, this is just a nomination. Somebody actually has to be appointed by the probate court in order to stand in the role. Guardianships and conservatorships end at age 18. So if we want to provide more guidance or oversight for our children, again, trusts are generally a better tool for that. Trusts allow you to provide financial management until ages of your choosing. Trusts can be created for the benefit of your children for their entire lives or until certain age markers, say 25, 30, or 35. So there's a real benefit there. And just to sort of recap, the guardian under the will or the guardian that in the probate court is responsible for care and custody, whereas the conservator would be responsible for a child's money, if they were appointed. How can I provide for my favorite charities in my estate plan? What are the tax benefits of doing so? So first, you can make lifetime gifts, and you don't need an estate plan necessarily in order to make lifetime gifts. We all know, you can write a check and you'll get to your church or charity of choice, and you'll get the 501c3 letter or some other memorialization of your gift. And presuming you itemize your deductions, you're able to receive some income tax benefit for doing that. But when we use thoughtful gifting under our estate plan, there are a lot of potential tax benefits. With lifetime gifts, they may result in income and gift tax deductions. One important potential income tax deduction is that you can use your IRAs to make charitable gifts, and that can be a substitution for your required minimum distribution if you're over the age of 72. You can gift up to $100,000 as a qualified charitable distribution. You also have the opportunity using charitable gifting to make gifts of appreciated assets. And if you make a gift of an appreciated asset, you generally don't have to, you get the gift tax deduction or the income tax deduction for the charitable gift for the fair market value of that gift, but you yourself do not generally need to pay or recognize the capital gain if it's a highly appreciated asset. So that's a really great, if you've got, say, your Apple stock that's 20 years old and you don't really need that income, but you would like, you'd like to make a significant charitable gift. You gift that stock, whether through your estate or during lifetime gifting. The charity doesn't need to pay the taxes for that gain. You get the credit for having made the big gift. There's a real value there. There are opportunities to receive continued benefit after you make the gift. These are three very complex estate planning tools: charitable remainder trusts, pooled income funds, and charitable gift annuities. Again, these are great vehicles if you have highly appreciated property. I was running some calculations that if you, say, had $1 million worth of Apple stock and you gifted it to a charitable remainder trust, you could, using this vehicle, basically write up a document that allows you, a 65-year-old, say, to get $50,000 a year for as an annuity and receive a one-time $200,000 income tax deduction for that gift. So it can still actually be an income stream, and you can get the tax benefits of giving to charity. Pooled income funds work basically just like a charitable mutual fund, where you can get a charitable deduction while still receiving income. And charitable gift annuities operate much like traditional annuities, but are valued at the time of gift to again give you an income tax deduction. Lastly, gifts at death result in estate tax deduction. So that's a great way to limit your estate tax exposure. Again, if you've got an estate over $1 million, or if you're a married couple with an estate over $2 million. Who should be the owner or beneficiary of my life insurance and retirement accounts? If the insured owns the life insurance policy, the death benefits are subject to estate tax. This is really, really important because I think there's a lot of confusion in this area. You can use irrevocable trusts to provide for your desired beneficiaries while basically sheltering those benefits from estate tax. If you use an irrevocable trust to own a life insurance policy, there are certain administrative costs associated with doing so, but the death benefit is completely outside of your taxable estate. When I think about it for my contemporaries who have young families, our term life insurance policies are oftentimes, if not the most significant asset that would come to be at our deaths. It's close to it. And the life insurance trust is an irrevocable life insurance trust is a way to make sure that in the event something were to happen to me, say, the life insurance proceeds would not be taxable to my estate. You can also, though, name charities as beneficiaries, and if you do that, then the life insurance does basically get deducted from your taxable estate. With respect to life insurance, or excuse me, with respect to retirement benefits, our general recommendation is to name surviving spouses as primary beneficiary because basically a surviving spouse still has the ability to roll over a retirement account and it can operate the same way it did for the living person. But if you have a non-spouse beneficiary named on your retirement account, whether it be a trust or a child or some other family member, there are very, very few exceptions now. Generally speaking, all retirement account payouts need to be made within 10 years of the initial owner's date of death. The major exceptions are for minor children and disabled beneficiaries. These are called eligible designated beneficiaries. But the beneficiaries of retirement accounts other than charities have to pay this income tax, and they have to receive the funds under a specific timeline. That's why our recommendation is with respect to retirement accounts, if you've got any charitable inclinations, using retirement funds is a great way to direct your charitable contributions. We talked about qualified charitable distributions during our last slide. Another little note on this as we talk about retirement accounts and we talk about insurance is that insurance is generally not subject to income tax, but it is subject to estate tax. And so again, that's another reason why we generally recommend having insurance owned by an irrevocable trust if you've got what would otherwise be a taxable estate. All right, it looks like that's the meat and potatoes of my presentation. I'm going to take off the share screen and open it back up to Stephanie and any questions that folks may have.
Awesome. Thank you, Tony. That actually, I had a question on your last slide, so you answered it before I got to ask it, so that was perfect. Thank you so much. A lot of incredible information, useful information, and important information for sure. So I know my brain is thinking, and I wanted to open it up first before I ask my questions. If anyone has any questions from our participants, if anybody would like to open it up, we can certainly, you can unmute, ask your question, or type it in the chat box. Raise your hand too if you have any questions. Tony, I have a question from Kim here. She said, great information, thank you. Can you describe what a blood trust is?
A blood trust. I'm going to be honest with you, Kim. I don't know. I'm unfamiliar with the term. A blood trust.
I don't know if I've ever heard that. If you haven't heard it, I definitely haven't heard it.
So I've just sort of gave a quick Google search to see if I'm more familiar with another term. It looks like there's some discussion here of bloodline trusts or bloodline wills, which that might be sort of the general strategy, Kim. And the idea there is the maintenance of an estate plan that continues to direct assets down your particular family line. And what I mean by that, and a lot of estate plans operate this way, is that when we're creating the plan is for your spouse and then for your descendants going down the line. So if you say have a child who has a spouse, if your child passes away, their share wouldn't pass to the spouse. The share would pass to the kids, if any. And if there are no kids, that share would move over to any other family, any other people in your direct bloodline. So the idea there, it's particularly important if there's a business interest or something like that, but it's also just sort of accounting for the idea that you want, you might want your own sort of direct bloodlines to benefit from your estate, rather than a surviving spouse or somebody who might remarry and have another family of their own, and just sort of spreading it out that way. Also, I imagine could be beneficial in the event of a subsequent marriage. If you, as a grantor, are remarrying and you have children from a prior spouse, you might develop and design trusts that are specifically for the benefit of your own descendants and not necessarily for your spouse. But I have to give you the caveat there. We don't operate with that terminology. So that's just
thank you. No, that's good. Thank you, Tony. A question from Greg. What happens when a spouse is named in an irrevocable trust and there is a divorce or the spouse passes away first?
So that's a great question, Greg. The first sort of component of this is we have some state law that comes into the rescue. Unless there is a legal agreement, say a separation agreement or a judgment of divorce, which dictates that an ex-spouse needs to continue to be named as a beneficiary under an irrevocable trust, there are certain legal presumptions that are made after a couple gets divorced that takes the ex-spouse out of the equation. But those laws would get trumped by something like a judgment of divorce. So oftentimes under a separation agreement, the spouse that has more funds may be required to maintain a life insurance policy for the benefit of their former spouse to make up for any future obligations that the moneyed spouse would have if they were to pass away in an untimely fashion. So in that event, the separation agreement, the judgment of divorce would dictate. But to take another example, if you've if you're married and you have your spouse named as on a retirement account as the primary beneficiary, well, if you get divorced, if the divorce is finalized and then you pass away, there's a presumption that right up until you died, you had the ability to make that change, and the presumption is you wanted to make that change. And so the legal presumption is that the ex-spouse is treated as having predeceased you, as having died before you, and then the contingent beneficiaries, usually kids, if any, would then become the actual beneficiaries. So that's sort of an indirect, I think, answer to your question, and that sort of also touches on the second part here. If the spouse passes away first, there's, generally speaking, in an irrevocable trust and also in a revocable trust, there's a designation whether your gift is only made to that person if they survive you, or if that person doesn't survive you, there's generally a designation for what happens to the assets after that. So in a traditional family trust planning environment, you might name your spouse if your spouse survives you, and if your spouse doesn't survive you, than to your what we call descendants by right of representation, and that's basically just making sure that your family lines are all sort of equally benefiting.
Perfect. Okay. This is a good one. How does one select an estate planning attorney, and what is approximate cost?
So question one, how does one select an estate planning attorney? My answer is carefully, because there are a lot of estate planning attorneys here in the city of Worcester, all throughout the Commonwealth of Massachusetts, all throughout the country. A lot of folks, I think, subscribe to a one-size-fits-all methodology that may be a little bit more cost-friendly, maybe a little bit less expensive. But there are a lot of considerations that go into putting together a thoughtful estate plan, and so I think it's important to really consider carefully the selection of an estate planning attorney. The way I think most people do it is they hear from satisfied clients. Most people do have an estate plan, and if people have a good experience and working with their estate planning attorney, I think referrals are generally how it kind of operates. But we have great estate planning firms that do estate planning work right here on Main Street here in the city. Obviously, to Bowditch and Dewey's horn, we've got a team of I believe 12 estate planning attorneys here in Worcester and Framingham, and then also in a Boston office. You don't need to go with a big firm, but there's certainly benefits to doing so. As far as the cost of an estate planning attorney, it really depends. But the tax planning trusts are generally a little bit more expensive than just the simple wills. It sort of makes sense that would be the case. Things like your power of attorney, healthcare proxy, Hipaa authorization, those are largely form documents, so they should be really inexpensive regardless of who prepares them. In our office, the preparation of simple wills and all of those, the power of attorney, healthcare proxy, Hipaa authorization, sort of that suite of documents, we generally offer a flat fee of between $1,250 and $1,500 for the full suite. If we're talking about tax planning, the range expands greatly, and obviously the cost comes up as well. It ends up being something in the order of between $4,000 and $6,000 generally.
Thank you. Okay. Kim has a question here.
Yep.
Can a trust in one state, Massachusetts, oversee assets in another state, like property?
Absolutely, Kim. And it's a great idea if you do have assets in another state. It's a great idea to have your Massachusetts trust have own title to that property, because then you're able to avoid probate in that other state. So in an example, if you own a cottage just over the line in Rhode Island or in Connecticut, and you are primarily a Massachusetts resident for tax purposes, at your death, if you don't have that Connecticut property held in trust and you're the sole owner of that property, then you need to open a Connecticut, your personal representative would need to open a Connecticut or Rhode Island probate in order to dispose of or distribute that property. If the asset is owned by a trust, then the trustee would have the ability to manage that asset, sell it if that's what you want, if that's what you as the grantor wanted to have happen. And again, you wouldn't need to involve the probate court either here or in that other state. So great question, and it's another real benefit to trust planning.
Okay. All right, we've got one last one here. So recommendations, if you could comment on recommendations for Roth IRA strategies post-death, for example, put into a trust, gift directly to a higher earning child, etc.
Okay, so Roth IRAs are an interesting vehicle, just because the income tax obligation has largely already been provided for. It's no longer as beneficial to consider the potential estate tax savings or income tax savings of transferring those assets to a trust. To a charity. You can direct those assets to a higher earning child, just because their incremental tax benefit would be better than it would be to a lower earning child. The other option is you can name your trust as the beneficiary, with the direction that that the trustee have the discretion for how different assets are distributed. Your trust can dictate a lot of these terms. It can dictate that, say, if you've got charitable gifts and you've got retirement accounts in your trusts, you can dictate that the charities will benefit specifically from the retirement accounts if the retirement accounts are available. Well, the trustee also has the ability to optimize tax positioning for the beneficiaries. And so in a well-crafted trust, if the trust is named as the beneficiary of the IRA, you can sort of maintain that tax benefit. But for whoever asked the question, I'd be happy to continue the discussion offline. You can shoot me an email. I can perhaps put that back up, or we can just discuss it in more detail.
I'll put your email in the chat here, Tony.
Great, thank you, Stephanie.
Yeah, absolutely. Perfect. Any last questions before we go? Perfect timing. All right. Any final words, Tony, to leave us with?
Well, I really just want to thank you all so much for joining us this morning. I would have loved to see you all in person. I know a few of you. It would be great to catch up again. I had the easiest, or it would have been the easiest commute in the biz, because my office is actually just on the 3rd floor. I'm literally one floor above the chamber at 311 Main Street here in Worcester. But I certainly would welcome the opportunity to continue this discussion with any and all of you. You've got my contact information from the presentation, and estate planning as a whole, I liken it to eating your vegetables. A lot of people, they don't like doing it, but you always feel better once you did. Never regretted that stalk of broccoli. So I think that's how I'll leave it. That's what I want you to think about as you consider potentially updating or creating an estate plan for yourself.
Absolutely. Well, thank you, Tony, so much. Kim says thank you. Excellent presentation in the chat. So certainly well received, and you are an expert in your field. And of course, being a little biased as you are upstairs and a proud member of the chamber and supporter. So I would, of course, recommend you and everyone at Bowditch for anyone's needs here. But it's been a pleasure. Really enjoyed spending the first hour of my day with you all, and Tony, learning all about this information that I will certainly take back with me. So all of you that are on the call, like I mentioned, I'll send out the recording. Tony, the slides, did you want me to send those out as well?
Sure.
Yeah. All right. And then if you, of course, you have any questions, I put Tony's email in the chat, and feel free to reach out to me for anything else. Enjoy the rest of your Tuesday, everybody. Thank you so much.
All right. Thanks, guys.
Bye-bye.